The morning it arrived, I was on my second cup of coffee. Nothing about that day felt different. Birds outside, quiet road, the kind of slow Tuesday that makes you think the world is still okay. Then I heard the knock. Not a regular knock, the kind the mailman gives when he needs a signature. I opened the door, and he handed me a thick envelope, cream-coloured, with a return address I didn't recognise. A law firm? Out of state. I signed for it without thinking. I set it on the kitchen counter and stared at it for a full minute before I opened it. I don't know why. Some part of me already knew that whatever was inside had weight to it. The kind of weight that changes your morning, changes your week, maybe changes more than that. I slid my finger under the flap. Notice of adverse possession claim, parcel ID 4471B, Ridgeline County. I read it twice. Then a third time. That parcel. My parcel. The cabin land. If you've never been to that property, I can't fully explain what it means to me, but I'll try. Picture a dirt road that winds for almost 2 miles off the main highway, cutting through pine trees so tall they block the afternoon sun. At the end of that road, there's a clearing, and in that clearing sits a small cabin. Nothing fancy, nothing modern, with a covered porch facing east so you catch the sunrise over the ridge line. My father built that porch with his own hands. I'm talking about actual hands, no contractor, no crew. Just him, a pile of lumber, a summer, and the kind of stubbornness that doesn't exist much anymore. Every wall of that place has a memory in it. Every floorboard. The hook by the door, where he hung his hunting jacket. The fire pit out back where we'd sit until the wood burned down to nothing. That land wasn't just a property to me. It was the last physical place in the world where I could still feel close to him. And now a stranger, with a lawyer, was claiming it was his. I set the letter down on the counter. Someone was trying to steal my land, and they had a lawyer. My father wasn't a wealthy man. He worked 31 years at a lumber yard in a small town that most people drive through without stopping. He didn't take vacations. He didn't buy new trucks. He packed his lunch every single day, and he saved, quietly, steadily, the way people from his generation did, without ever talking about it. In 1987, he found the land. He told me once that he'd heard about it from a guy at the yard who knew a guy who was selling off a parcel up in Ridgeline County. No realtor involved. No bidding war. Just 2 men shaking hands on a cash deal in a county recorder's office and a deed with my father's name typed across the top. 43 acres. Mostly wooded. A creek running along the eastern edge, and that clearing in the middle, the one that would eventually become everything. He paid $11,000 for it. He drove me up there that same weekend. I was 9 years old. I remember standing in the clearing and looking up at the tree line and thinking it was the biggest, quietest place I'd ever been. My father put his hand on my shoulder and said, "This is ours now. Don't ever let anybody tell you different." I didn't fully understand what he meant then. I do now. He built the cabin over 3 summers, a little more each year. The foundation first, then the walls, then that porch. He wasn't in a rush. He said the land wasn't going anywhere, and neither was he. By the time I was 12, we were sleeping there on weekends, cooking on a camp stove, hauling water. By the time I was 16, it felt more like home than our actual house did. We hunted every fall, deer season, sometimes turkey. We'd wake up before dawn and walk the ridge in the dark without flashlights because we knew every root and rock by memory. Afternoons we'd fish the creek. Evenings we'd sit on that porch and not say much because there wasn't much that needed saying. That land was our language. When my father passed, 6 years ago, heart attack, no warning, the cabin was the hardest part of the estate to think about. Not because of any legal complexity, because of what it meant. But we did it right. Hired a probate attorney, went through the county process, had the deed formally transferred into my name. Every step documented. Every form filed. His name came off. Mine went on. Now here is something important to understand because it becomes very relevant later in this story. A property deed is the legal document that proves ownership of real estate. It includes the legal description of the land, the name of the previous owner, and the name of the new owner. When a deed is properly recorded with the county, it becomes part of the public record. That recorded deed is the foundational proof of who owns the property. Without a valid recorded deed in your name, ownership can be challenged. With one, you have the strongest possible legal starting point. My deed was clean. Recorded. My name, my parcel, my county. No liens, no disputes, no gaps in the chain of title going back to 1987. I visited the cabin a few times a year. Not as much as I should have, life, work, the usual excuses, but I paid the property taxes every year without fail, just like my father had. It felt like the least I could do. A small ritual, a way of saying I still see this land. It still belongs to us. The cabin sat at the end of that 2-mile dirt road, surrounded by trees, with no neighbours for miles. Isolated. Quiet. The kind of property most people never even know exists. I thought that invisibility protected it. I was wrong. I didn't just sit there after opening that letter. I did what most people do when something blindsides them. I started searching. I typed the name from the letter into my browser. Marcus Hale. It didn't take long to find him. He had a website, clean and professional, for an LLC called Hale Property Solutions. The tagline on the homepage said something about identifying undervalued rural real estate opportunities. There were no photos of him on the site, just a contact form, a phone number, and a list of counties they operated in. My county was on that list. I dug deeper. Court records, news articles, property databases. What I found made my stomach drop. Marcus Hale wasn't a neighbour who'd wandered onto my land by accident. He wasn't some confused local who thought the property lines were different. He was a professional. He ran a real estate LLC that specifically targeted rural properties with what he called weak or ambiguous title chains. That was his business. Finding land where the ownership history had gaps, deaths, missing heirs, incomplete paperwork, and then filing legal claims against it. He wasn't confused. He was calculated, and I needed to understand exactly what he was claiming, so I called an attorney that same afternoon and asked her to explain it to me plainly. What Hale was pursuing is called adverse possession. It is an actual legal doctrine, and it exists in every state in the country. The basic idea is this: if someone openly occupies and uses a piece of land for a long enough period of time without the true owner's permission and meets certain legal requirements, they can eventually claim legal ownership of that land even if they never paid for it. The requirements vary by state, but generally the occupation has to be open and visible, meaning not hidden. It has to be continuous, meaning no long breaks. It has to be hostile, which in legal terms doesn't mean aggressive. It just means the person is using the land as if they own it, without the actual owner's consent. And in many states, the claimant also has to pay property taxes on the land during that period. The time period required is usually somewhere between 10 and 21 years, depending on the state. It was originally a doctrine meant to resolve situations where land sat abandoned for generations and someone had genuinely been farming or maintaining it for decades. A reasonable concept in theory, but what Marcus Hale was doing had nothing to do with genuine long-term use. He had turned adverse possession into a business model. His claim stated that an agent working on his behalf had been maintaining my property for the past 12 years. Brush clearing, fence repair, seasonal upkeep, trail maintenance. He said this agent had been doing this work openly and continuously without my knowledge or permission for well over the statutory period required in my state. He had receipts. He had photographs. He had a written timeline going back over a decade with dates and descriptions of every visit. I sat with that for a long moment. He wasn't just throwing something at the wall and hoping it would stick. He had built a case. He had documentation. He had a lawyer who filed a formal legal action in county court, and I had a deed and a lot of memories. I remember thinking, this is not a misunderstanding I can clear up with a phone call. This man came prepared, and if I didn't come just as prepared, I was going to lose my father's land to a stranger who had never once set foot on it with any honest intention. That thought, that specific thought, was the moment the fear turned into something else. I found an attorney named Patricia Owens through a referral from a friend who had dealt with a property dispute a few years back. She was a real estate litigation attorney, 20 years of experience, small firm, no nonsense. I called her the morning after I received the letter, and she got me in within 2 days. I brought everything I had: the certified letter, Hale's claim documents, my deed, the probate paperwork from when my father passed. I laid it all out on her desk and she went through it quietly, page by page, without saying much. When she finished, she leaned back in her chair and looked at me. She said my deed was solid. She said the chain of title from my father to me was clean. She said, under normal circumstances, a recorded deed in my name should be more than enough to shut something like this down quickly. But then she said the word that changed the temperature in the room. She said, however, she told me, adverse possession cases are not always about who has the deed. They are about use. They are about physical presence on the land over time. A court doesn't just look at paperwork, it looks at evidence of who was actually there, who was actually maintaining the property, who was treating it as their own. And if Hale's side could produce convincing documentation of 12 years of continuous maintenance, a judge would have to weigh that against my ownership record. She said she had seen cases where people with perfectly clean deeds lost land because they couldn't prove they were paying attention to it. She was being honest with me. I appreciated that, but I walked out of her office feeling worse than when I walked in. By the time I got home and explained the situation to my wife, she had the same reaction most people would have. First disbelief, then anger, then that quiet, creeping fear that sets in when you realize something serious is actually happening and it isn't going to resolve itself. She asked me if we could lose the cabin. I told her I didn't know yet. That was the wrong answer, but it was the only honest one I had. That night, after she went to bed, I sat at the kitchen table with my laptop and read everything I could find about adverse possession cases. I read court decisions. I read legal forums. I read stories from people who had been through similar situations. Some of them won, some of them didn't. The ones who lost almost always lost for the same reason. They couldn't produce enough evidence of their own continuous ownership and engagement with the property. A deed proves you bought it. It doesn't prove you kept it. A few days later, Patricia called to tell me that Hale's attorney had officially filed a quiet title action in Ridgeline County Court. A quiet title action is a lawsuit that asks a court to officially settle who owns a piece of property. It essentially forces the question into a legal arena and asks a judge to look at all the evidence from both sides and declare a winner. Once it's filed, you can't ignore it. You can't wait it out. You have to respond, and you have to show up, and you have to fight. The clock was running. Patricia told me I needed to start gathering every piece of documentation I could find that proved my continuous ownership, tax records, any correspondence about the property, photos, anything with a date on it that showed I had been actively maintaining my claim to that land over the years. That evening, I drove to my mother's old house, where boxes of my father's paperwork had been sitting in the basement since we cleared it out after he passed. I hadn't gone through most of them. There hadn't seemed to be a reason to. I hauled 4 boxes up from the basement and loaded them into my car. I drove home and carried them to the kitchen table, and I started opening them one by one. I was looking for anything. I didn't know exactly what I needed. I just knew I needed something, and I knew that if it existed anywhere in the world, it was probably in one of those boxes. My wife came downstairs around midnight and found me surrounded by old folders and envelopes and papers, squinting at documents under the kitchen light. She didn't say anything. She just made 2 cups of coffee, set one next to me, and sat down across the table. And we started going through it together. We went through those boxes for 3 nights straight. My father was not a digital man. He didn't have spreadsheets or cloud storage or organized folders on a computer. What he had was paper, envelopes stuffed into envelopes, receipts held together with rubber bands that had dried out and crumbled when you touched them, handwritten notes on the backs of other documents that you almost threw away before you turned them over. It was slow, careful work. My wife made a system, 1 pile for anything property-related, 1 pile for everything else. We didn't skip anything. We unfolded every piece of paper. We read every envelope before we set it aside. And then, halfway through the 3rd box, I found them. A rubber-banded stack of envelopes, each one from the Ridgeline County Tax Assessor's office. Each one opened, with a receipt tucked back inside. I pulled them out one by one and laid them on the table in order. 1987, 1988, 1989, all the way forward, year after year, in my father's name, and then, after the probate transfer, in mine. Property tax payment confirmations every single year for the parcel at the end of that dirt road. My wife looked at me from across the table. I don't think either of us fully understood in that moment what we were holding, but something in the air shifted. I gathered the entire stack carefully, put them back in the envelope, and called Patricia first thing the next morning. She went quiet when I described what I had found. Then she said, "Bring them in today." "Not tomorrow. Today." I drove to her office that afternoon and set the stack on her desk. She went through each receipt slowly, checking dates, checking the parcel identification number on each one, cross-referencing against the property records she already had on file. When she looked up, something in her expression had changed. She said, "This changes everything." Now here is why that mattered so much, because the legal reasoning behind it is something every property owner needs to understand. In most states, the continuous payment of property taxes by the true owner is one of the most powerful pieces of evidence you can present against an adverse possession claim. Paying taxes on a piece of land is a formal, documented, government-recorded act of ownership. It signals to the state, to the county, and to any court that you are acknowledging this land as yours and accepting the financial responsibilities that come with that ownership. Many states go even further. They require that the person making an adverse possession claim must also have been paying taxes on the land during the period they are claiming. If the true owner was paying taxes the entire time, that alone can defeat the claim in certain jurisdictions. And even in states where tax payment isn't an absolute requirement, a complete and unbroken record of tax payments by the true owner makes it extremely difficult for an adverse claimant to argue that the owner abandoned the property or stopped treating it as their own. What I had in that stack of envelopes was an unbroken paper trail of ownership going back decades. Year after year, someone in my family had written a check to Ridgeline County and said, "This land is ours, and we are paying for the right to say so." Patricia said Hale's entire claim rested on the argument that I had been an absentee owner who had essentially ignored the property for years. These records directly contradicted that narrative. Every single year, without fail, taxes were paid. I felt something loosen in my chest for the first time since that certified letter arrived. But it didn't last long. Patricia kept going through the stack, and about 2/3 of the way through she stopped. She went back one envelope, then forward again. Then she set the stack down on the desk and looked at me with an expression that was careful and measured in the way that attorneys get when they are about to tell you something they don't want to tell you. She said, "There's a gap." I looked at the envelopes on her desk. She spread them out slightly so I could see the years printed on each one. 2008, then nothing. Then 2012, 3 years missing. 2009, 2010, 2011. No receipts, no confirmations, no documentation of any kind. 3 years. I told her I paid those years. I told her I know I paid them because I never missed a year, not once since my father transferred the deed to me. I told her the records had to exist somewhere. She nodded slowly. She believed me. But she also told me what I already knew. Believing it and proving it are two completely different things. And Hale's attorney, the moment they saw our tax record evidence during the discovery phase of the case, was going to go straight for that gap, like a man who had been waiting for exactly that door to open. She was right. Within 2 weeks, Hale's legal team filed a response to our evidence submission. They acknowledged the tax records, and then they highlighted the 3 missing years with the kind of precision that told me they had either already found the gap on their own or they had been counting on us finding exactly this problem. Their argument was simple and clean. 3 years without documented tax payment during the exact period their client's agent was actively maintaining the property. 3 years where, by their telling, Marcus Hale's operation was the only party demonstrably engaging with the land. I sat in Patricia's office and read their filing and felt the floor shift under me again. 3 years. That was all he needed. I am not a lawyer. I am not a private investigator. I am not someone who spent his career tracking down documents or building cases or navigating bureaucratic archives. I am a person who owns a cabin that his father built, and I was not going to lose it because of 3 missing pieces of paper. So I did what I had to do. I started from the beginning, and I worked forward. The first place I went was the Ridgeline County Assessor's office. I drove up there on a Wednesday morning, walked in, and asked the clerk at the front desk if she could pull the tax payment history for my parcel going back to 2008. She was friendly, efficient, typed in the parcel number without hesitation, and then her expression shifted in that subtle way that tells you the answer is not going to be what you were hoping for. She told me that the county's physical records from approximately 2008 through 2012 had been significantly damaged. There had been a flood in the basement of the county records building in late 2011. Water damage, mold, destroyed boxes. A lot of documents from that period simply did not exist anymore in any recoverable form. They had digitized what they could before the damage was too severe, but the digitization had been incomplete. Many individual parcel records from those years had gaps or were entirely missing. She was apologetic. She printed me what she had, which showed payments before and after the damaged window, and handed it across the counter with the kind of look that said she had delivered this same news to other frustrated people before me. I drove home and called Patricia and told her what I'd found. She told me to try the State Archive next. Some counties, she explained, submitted duplicate records to a state-level property database as a backup. It wasn't universal and it wasn't guaranteed, but it was worth checking. I spent the better part of 2 days navigating the State Archive system. I made calls, filled out records request forms, waited on hold, got transferred, explained the situation 4 separate times to 4 separate people. At the end of it, the answer was the same. Ridgeline County's records from that period were not among the counties that had submitted reliable state-level backups. The flood had taken out both copies. I sat in my car in the parking lot of a gas station after the last phone call and stared at the windshield for a while. Then I thought about what my father would have done. He would not have stopped. He would have gone back further. He would have looked in places that other people forgot to look. He would have trusted that if something happened, there was a trace of it somewhere, because that is how the physical world works. Money moves, paper moves, and somewhere, on someone's record, that movement leaves a mark. I called my bank, not the county, not the state, my bank. I asked them if they could pull records going back 15 years. The person on the phone told me that standard record retention was 7 years, and anything beyond that would require a formal research request and would take time and possibly a fee. I told them I needed it, and I would pay whatever they needed me to pay. 3 weeks later I had them. Scanned images of original bank statements from 2009, 2010 and 2011, 12 months of transactions per year, every line item, every check number, every cleared payment. I went through them line by line, and there they were. 3 checks, one in the spring of 2009, one in the spring of 2010, one in the spring of 2011. Each one made out to the Ridgeline County Tax Office. Each one for the exact amount that matched the tax assessment for my parcel in those years. Each one showing a cleared status, meaning the check had been received, deposited and processed by the county. The county's copy was gone, but my bank's copy of the transaction was not. I called Patricia and I read her the check numbers and the amounts and the cleared dates over the phone. She was quiet for a moment and then she said, "Get me those documents as fast as you can." I drove the printed statements to her office the next morning, but there was something else I needed to follow up on, and it had been sitting in the back of my mind since early in the investigation. Hale's maintenance claim relied on the testimony and documentation of this so-called agent who had supposedly been clearing brush and repairing fences and maintaining trails on my property for 12 years. The affidavits described regular visits, seasonal work, specific improvements made to the land over time. My property was isolated. The dirt road leading to it was long and not connected to any main route in a way that made it easy to access without purpose. You didn't end up on that road by accident. You went there deliberately. I thought about whether anyone in the area might have noticed a person regularly coming and going from that direction for over a decade. There was one family. They lived several miles away, and technically they weren't close neighbours by any suburban definition, but they were the closest people to my land in any direction. An older couple who had farmed that area for most of their lives. I had met them twice, briefly, years ago when my father was still alive. Patricia tracked down their contact information and reached out on my behalf. The husband was willing to speak with her. She drove out to see him in person. He had never seen anyone working on or near my property. Not regularly, not seasonally, not at any point in the past decade that he could recall. He knew the road. He knew the land. He said the only vehicles he ever saw on that dirt road were mine, and before that, my father's. He signed a sworn affidavit saying exactly that. Patricia called me after she got back from that visit, and her voice had an edge to it that I hadn't heard before. A focused, sharp quality. She said, "I think he fabricated the maintenance timeline. I think every photo, every receipt, every dated record his team produced was staged or taken from somewhere else entirely." She said it quietly, like a person who is choosing their words carefully, because they know what they are about to say has serious consequences. I didn't say anything for a moment. Then I asked her what we do with that. She said we prove it. Here is Section 7, the courtroom, hearing build-up in clean TTS format. Patricia filed our response to Hale's quiet title action about 6 weeks after I first walked into her office. It was a substantial document. It included the original deed, the probate transfer paperwork, the full run of tax receipts from my father's boxes, and the 3 bank statements showing cleared checks for the gap years. It included the sworn affidavit from the neighbour confirming he had never once observed any maintenance activity on or near my property during the period Hale was claiming, and it included a formal motion for summary judgment. Summary judgment is a request that asks the judge to end the case before it ever reaches a full trial. The argument behind it is straightforward. If one side's evidence is so conclusive that no reasonable person could look at it and decide the other way, then there is no genuine dispute of fact, and the judge can rule on the law alone without putting everyone through a full hearing. Patricia's position was that between the deed, the unbroken tax record, once the bank statements were included, and the neighbour's affidavit directly contradicting Hale's maintenance narrative, there was no legitimate factual dispute left for a jury or a judge to weigh. She was confident. I had learned by that point that Patricia did not express confidence casually. Hale's legal team filed their opposition to the summary judgment motion within the deadline. I read it at my kitchen table the evening Patricia forwarded it to me, and I will give his attorneys credit for one thing: they were skilled at making weak arguments sound plausible on paper. They attacked the bank statements. Their position was that a cleared check made out to a county tax office was not by itself conclusive proof that the payment had been applied to my specific parcel. They argued that without the county's own records confirming receipt and application of those payments to Parcel 4471B, the checks could have been payments for anything: a different parcel, a miscellaneous county fee, an error that was later corrected. They said the bank records were suggestive but not definitive, and that a summary judgment standard required definitiveness. It was a reach, but it was not a frivolous reach. Patricia acknowledged that much. The judge reviewed both filings and denied the summary judgment motion. She set a full evidentiary hearing instead, scheduled for 6 weeks out. Both sides would present their evidence in open court. Witnesses could be called. Documents would be entered into the record. The judge would hear everything and then rule. Patricia called me after the scheduling order came through and told me to stay focused. She said the denial of summary judgment did not mean we were losing. It meant the judge wanted to look at everything in full before she decided. That was not unusual in a case with competing evidentiary records. I told Patricia there was something I wanted to raise with her, something that had been nagging at me since the discovery phase when I first reviewed Hale's photo evidence in detail. His team had submitted dozens of photographs as part of their maintenance documentation, photos of cleared brush, repaired fence lines, mowed areas, seasonal work. Each photo had a date stamp on it, and the dates were spread across more than a decade, creating the visual impression of a continuous, long-term maintenance operation. I had looked at those photos more times than I could count, and something about them bothered me in a way I couldn't fully articulate at first. The land in the photos looked right in a general sense: trees, terrain, rural property. But certain details felt off to me. The angle of a particular slope, the way the tree line sat against the sky in the background, the colour of the soil in one series of shots. I told Patricia I thought something was wrong with those photographs. I couldn't prove it sitting at my kitchen table, but I felt it. She listened without interrupting. When I finished, she was quiet for a moment. Then she told me she had already been thinking the same thing. Without telling Hale's legal team, without filing anything or making any noise about it, she had quietly engaged a forensic digital analyst to examine the photo files that had been submitted as evidence. The analyst had been working on it for 2 weeks by the time she told me. I asked her what that meant, what a forensic analyst could actually determine from a photograph. She explained it to me carefully. Every digital photograph taken on a modern device contains embedded data that is attached to the image file itself. This data is called EXIF metadata, which stands for Exchangeable Image File Format. It is written automatically by the camera or phone at the moment the photo is taken, and it records a significant amount of information: the date and time the photo was captured, the make and model of the device that took it, the camera settings used, and in many cases, the GPS coordinates of the location where the photo was taken. Most people never look at this data. Most people don't even know it exists, but it exists in almost every digital photo taken in the last 15 years, and it cannot be altered without leaving detectable traces if you know what to look for. Patricia said the analyst's report was expected within the next 10 days. Right before the hearing, I asked her what she thought he was going to find. She said she didn't want to speculate. She wanted to wait for the report, but I could hear something in her voice. The same focused, sharp quality I had noticed when she told me she thought the maintenance timeline was fabricated. The hearing was 3 weeks away when Hale's attorney submitted a final supplemental evidence package. More photos, more receipts, a more detailed written timeline of the maintenance work. It was clearly designed to overwhelm our side with volume, to make the record look so thick and so detailed that a judge would have difficulty dismissing it. I printed every page and read every word. And then I sat back and thought about a forensic analyst going through every single one of those image files, one by one, looking at data that Hale's team didn't even know anyone was examining. The morning of the hearing, I woke up at 4 a.m. and lay in the dark for a long time. My wife reached over in the dark and found my hand without saying anything. I thought about my father. I thought about that clearing. I thought about the porch he built with his own hands, facing east so you could watch the sun come up over the ridge. Then I got up, put on a suit, and drove to the courthouse. Here is Section 8, the photo metadata twist in clean TTS format. The courtroom was smaller than I expected. Wood paneling, fluorescent lights, a few rows of benches behind the bar. It was a county courthouse, not a television drama, and it looked exactly like what it was. A working room where ordinary disputes got resolved by ordinary process. I sat at the table with Patricia and tried to keep my breathing even. Hale's team was already there when we arrived. 2 attorneys, a paralegal, and a rolling cart stacked with binders. They were organised, polished, and completely at ease in a way that told me they had done this many times before in many different counties, across many different cases. And then Marcus Hale walked in. I had spent months reading about this man, researching his LLC, going through his legal filings, thinking about him in the abstract as a kind of force that had entered my life without permission. But I had never actually seen him in person. He was unremarkable. Medium height, well-dressed, somewhere in his 50s. He walked in quietly, sat down at his team's table, and opened a leather portfolio in front of him. He didn't look around the room. He didn't look at me. I watched him for a moment, and then I looked away. The judge entered, and the hearing came to order. Hale's attorneys went first. They laid out their timeline methodically and confidently. 12 years of maintenance activity, documented with photographs and receipts and written logs. They argued that their client's agent had been the only party actively engaging with the property during a period when the true owner of record was demonstrably absent and uninvolved. They acknowledged our deed and our tax records, but framed the gap years as evidence of exactly the kind of neglect that adverse possession doctrine was designed to address. They were smooth, they were prepared, they made it sound entirely reasonable. Then they began submitting the photographs into evidence. Patricia let them finish. She did not interrupt, did not object to the photos being entered, did not signal in any way that anything unusual was about to happen. She sat beside me and took notes in a legal pad with the calm, unhurried manner of someone who is waiting for exactly the right moment. When it was our turn, she stood up and walked the judge through our evidence systematically. The deed, the full tax record, the bank statements showing the 3 cleared checks from the gap years, the neighbour's affidavit. She was thorough and precise, and she built the ownership record back year by year until it was complete and unbroken in front of the court. The judge was attentive. She asked a few clarifying questions about the bank statements and how they connected to the specific parcel. Patricia answered each one directly. Then Patricia said she had one additional item to submit into evidence: a forensic digital analysis report prepared by a certified forensic imaging analyst examining the EXIF metadata embedded in the photographic evidence submitted by the opposing party. Hale's lead attorney looked up from his notes. Patricia submitted the report to the court and provided a copy to opposing counsel simultaneously as required. Then she began walking through the findings. Before I explain what the report found, I want to take a moment to explain what EXIF metadata actually is, because it is the reason this entire case turned in the direction it did. Every digital photograph taken on a smartphone or digital camera contains a hidden layer of data embedded inside the image file itself. This data is written automatically at the moment the photo is captured, and it records a detailed set of information about the circumstances of that photo. It records the exact date and time the photo was taken down to the second. It records the make and model of the device. It records the camera settings. And, in the case of smartphones and GPS-enabled cameras, it records the precise geographic coordinates of the location where the photo was taken, latitude and longitude, accurate to within a few meters. This data travels with the photo file everywhere it goes. It survives being emailed, uploaded, printed, and submitted to a court as a legal exhibit. And unless someone specifically strips it out or manipulates it, which itself leaves detectable traces, it is a reliable, machine-generated record of when and where that image was created. Hale's team had submitted dozens of photographs as evidence of maintenance activity on my property. The forensic analyst had examined every single image file. What he found was this: the date and timestamps embedded in the metadata were inconsistent with the dates printed or written on the photos as submitted. Several images that were presented as having been taken years apart showed metadata indicating they were taken within days or weeks of each other, suggesting a bulk photo session rather than years of continuous documentation. But that was not the worst part. The GPS coordinates embedded in a significant portion of the photographs did not match the location of my property. Not even close. My cabin sits at a specific set of coordinates in Ridgeline County. The GPS data embedded in Hale's maintenance photos pointed to a different rural property entirely, located in a different part of the state, more than 200 miles away. The terrain looked similar. The vegetation looked similar. To a casual observer reviewing printed photographs in a legal filing, it would not have been obvious. But the coordinates did not lie. Hale had submitted photographs of someone else's property and presented them to a court as documentation of maintenance activity on mine. Patricia presented this finding to the judge clearly and without drama. She pointed to the specific GPS coordinates in the analyst's report, cross-referenced them against the verified coordinates of my parcel, and showed the discrepancy in plain numbers on a document the judge could read directly. The courtroom was very quiet. Hale's lead attorney asked for a recess. The judge denied it. I did not look at Marcus Hale during any of this. I had made a decision that morning in the parking lot that I was not going to spend any of this moment watching him. I had spent enough months thinking about him. But when Patricia sat back down beside me and the judge began speaking, I did glance over once. His leather portfolio was closed in front of him. His attorneys were leaning in on either side of him, speaking in low voices. His face, which had been composed and unreadable all morning, was no longer either of those things. I watched Marcus Hale's face go from confident to pale in about 30 seconds. And then I looked back at the judge and I listened. Here is Section 9, the ruling and aftermath in clean TTS format. The judge did not take long. She had been on the bench long enough that you could tell she had seen people try to work the system before. She had seen manufactured evidence and coached testimony and legal filings designed to exhaust the other side into giving up. She was not angry in a dramatic way. She was something quieter and more final than angry. She was done. She summarized the record from the bench. She noted the unbroken chain of title going back to 1987. She noted the complete tax payment history once the bank statements were included, with no genuine gap in ownership activity. She noted the sworn affidavit from the neighbouring property owner directly contradicting the maintenance narrative. And she addressed the photographic evidence submitted by the claimant. She said the GPS coordinate discrepancy identified in the forensic analysis was not a minor inconsistency or a technical ambiguity. The coordinates embedded in the submitted photographs corresponded to a property located more than 200 miles from the subject parcel. There was no innocent explanation for that discrepancy that the claimant's counsel had been able to offer. The photographs had been presented to the court as documentation of activity on a specific piece of land. The metadata showed they were taken somewhere else entirely. She dismissed Marcus Hale's adverse possession claim with prejudice. With prejudice is a legal term that carries specific and permanent consequences. It does not simply mean the case is over for now, it means the case is over forever. A dismissal with prejudice bars the same party from filing the same claim against the same property ever again. Hale could not regroup, could not find new attorneys, could not wait a few years and try again with better fabricated evidence. That door was permanently closed. The claim was gone and it could not come back. The judge also referred the matter of the fraudulent photographic evidence to the State Bar Association for review of the attorneys involved, and she noted that the County District Attorney's Office would be receiving a copy of the hearing record for their consideration of whether criminal charges were appropriate. She thanked both parties for their presentations, gathered her papers, and left the bench. It was over in a single morning. I sat at the table for a moment after the judge left and did not move. Patricia was already organising her documents and making notes, the efficient, forward-moving energy of a person who had done their job well and knew it. She put her hand briefly on my arm and said, "You held on to the right things." I nodded. I couldn't say much right then. I watched Hale's legal team file out without looking in my direction. Hale himself walked out last, still carrying that leather portfolio, moving quickly, head slightly down. He did not look at me. He did not look at anyone. I drove back to the cabin that evening alone. The dirt road felt different somehow, though nothing about it had changed. Same ruts, same pine trees crowding in on both sides, same sharp turn about halfway up where my father always slowed down even when there was no reason to. I slowed down at that turn out of habit and something else. Gratitude, maybe. For the habits. For the things that stay the same. I parked in the clearing and sat on the porch for a long time. The sun was already behind the ridge by the time I got there, and the light was going grey and cool the way it does in early evening up at that elevation. The trees were still. There was no sound except the creek somewhere off to my right, moving the way it always moves, indifferent to courts and deeds and attorneys and all the ways that people try to take things from each other. I sat in the chair my father built, and I put my hands on the arms of it, and I felt the wood under my palms. For the first time in months, the land felt like mine again. Not because a judge had said so, though she had, but because I was sitting on it and nothing was pulling at it anymore. The weight that had been living in my chest since the morning that certified letter arrived had finally lifted, and what was underneath it was just the place itself. The clearing, the trees, the creek, the porch facing east. I stayed until it was fully dark. Several weeks after the hearing, Patricia called me with information she had pieced together through the legal network and public records. Marcus Hale had filed similar adverse possession claims on 6 other rural properties across the state over the preceding 4 years. All of them followed the same pattern. Isolated land, absentee or grieving owners, manufactured maintenance documentation, aggressive legal filings designed to make the defence process expensive and exhausting. Of those 6 other cases, 3 of the property owners had settled. They had signed documents transferring portions of their land or paying significant sums to make Hale's claims go away, not because the claims were legitimate, but because they could not afford the legal fight. They didn't have Patricia. They didn't have boxes of their father's papers. They didn't have bank records going back 15 years. They made the calculation that fighting was more expensive than surrendering a piece of what was theirs, and Marcus Hale had counted on exactly that calculation every single time. He wasn't just after my cabin. He had a business model. I thought about those 3 other families for a long time after Patricia told me. People who had lost something real because a predator with an LLC and a stable of attorneys had decided their grief and their isolation made them easy targets. I thought about what it must have felt like to sign those documents, to let go of land that someone in your family had held and loved and paid for honestly I thought about my father's voice in that clearing when I was 9 years old. "This is ours now. Don't ever let anybody tell you different." He said it to a 9-year-old boy who didn't fully understand what it meant. It turned out he was saying it to me now too. I am not a legal expert. I am not someone who knew anything about adverse possession or quiet title actions or EXIF metadata before that certified letter landed on my kitchen counter. Everything I learned because I had no choice, because something I loved was under threat and walking away was never going to be an option. But I came out the other side of this with things I wish I had known before it started. And if you own rural property or inherited land or have a family cabin or a piece of ground that meant something to someone before it meant something to you, I want you to hear this clearly. Keep your tax records. Not for 7 years. Not for 10 years. Forever. Put them in a box, put the box somewhere dry, and never throw them away. The county can lose its records. The state archive may not have a backup. Floods happen, fires happen, systems fail. The copy in your possession may be the only copy that exists. Those 3 cleared checks from my bank statements were 15 years old when I needed them. If I had cleaned out old financial records the way most people do, they would have been gone. The entire case might have turned out differently. Keep everything. Know your state's adverse possession statute. Every state has one. The time periods vary. The requirements vary. Some states require the adverse claimant to pay taxes. Some do not. Some have shorter statutory periods than others. You do not need to become a property attorney, but you need to spend 30 minutes understanding the basic rules in your state so that if something like this ever happens to you, you are not starting from zero the way I was. Never ignore a certified legal notice. I know it is tempting to set something alarming aside and hope it resolves itself. It will not resolve itself. A quiet title action has a response deadline. Missing that deadline can result in a default judgment against you, regardless of how legitimate your ownership is. The moment something arrives with a law firm's return address and your property's parcel number on it, you pick up the phone and you call an attorney. That same day, if possible. Document your relationship with your property. Take photos when you visit. Date them, geotag them, keep them in a folder somewhere organized. Save any correspondence related to the land. Keep records of any maintenance or improvements you make. You do not need to be obsessive about it. You just need to leave a trail that shows a court, if it ever comes to that you were there, that you were paying attention, that you were treating the land as yours because it was yours. And understand that the law has tools designed to protect honest ownership. The deed system exists for a reason. Tax records exist for a reason. The requirement that evidence be authentic and verifiable exists for a reason. When someone tries to subvert those systems with fabricated photographs and manufactured timelines, those same systems have the capacity to expose the fraud if you know how to use them. Patricia knew how to use them. The forensic analyst knew what to look for. The neighbour knew what he had and had not seen. The truth was there the entire time. It just needed someone willing to go find it. I think about Marcus Hale sometimes. I think about where he is now, whether the district attorney's office followed through, whether the state bar took action against his attorneys, whether the 3 families who settled ever found out what happened in that courtroom and what it might have meant for them if they had been able to hold on a little longer. I don't have answers to most of those questions. What I have is the cabin. I went up last fall for the first time since the hearing, for the first time in a long time where the visit felt clean. No weight behind it, no legal cloud sitting over the clearing, no voice in the back of my head reminding me that something was unresolved. I got there in the early morning, and the sun was just coming up over the ridge, the way it always does when you face east and get there early enough to catch it. I sat on my father's porch, and I drank coffee, and I watched the light move through the trees, and I did not think about anything complicated. My father paid for that land once. $11,000, a handshake, a deed with his name on it. He paid for it with 31 years of packed lunches and no vacations, and a stubbornness that does not exist much anymore. I had to fight to keep it. It cost me months of fear and boxes of old papers and bank records from 15 years ago, and an attorney who knew exactly what she was doing, and a forensic analyst who understood that photographs tell more truth than the people who take them sometimes intend. But it is still ours. And that is the only ending this story was ever going to have.